Good evening, everyone. My Lord Justice Srikrishna, former Judge of the Supreme Court of India, Mr. Thakker, President of the Bombay Bar Association, Dr. Dhruti Kapadia, the proud family members of Dr. Dhruti Kapadia, distinguished senior advocates, members of the bar, ladies and gentlemen. It gives me great pleasure to welcome you all for the launch of Dr. Dhruti Kapadia's book titled Third Party Funding in Dispute Resolution in India, Pros and Cons. I won't call her Dr. Dhruti Kapadia, I'll just say Dhruti, because that's how we all know her. Dhruti is, I'm sure, a familiar face around the courts. We've seen her running up and down the staircases, left and right. And Dhruti is somebody who really needs no introduction. But I just asked Dhruti's junior, I said, just give me a small write-up about Dhruti. And I noticed, I said that Dhruti Kapadia has more letters after her name than actually within her name. Because Dhruti is Dr. Dhruti Kapadia, BLS, LLB, LLM, PhD, and some multiple diplomas. Solicitor. And she's standing counsel for MTNL, MCGM, SRA. So as you can see, there's an entire alphabet behind her surname. And I think it's a testament to the regard that the court has for her, the respect that is given to her, that she's appointed to so many panels to represent the government of India. Now, her book, which we are here today to launch, is on third-party funding in dispute resolution. And frankly, I think it's quite a contentious and polarizing subject. Because when you all will all have the benefit of reading her book, Dhruti's analyzed it from two perspectives. One is that you may have a situation where there is a person who cannot have access to justice because they don't have the funds. So third-party funding is something that will actually enable a person to have access to justice. And therefore, she says, it could be a good thing. The con, obviously, is that is litigation an investment? Is litigation a market where people are going to now sort of hedge bets and say, okay, fine, I think this is a litigation worth investing in? And if people are funding litigation to make an investment, is it not going to protract litigation? Is it not going to foment litigation? And of course, there's the whole added aspect of what we all know as champati. Can advocates do this at all? Can advocates say, don't worry, as is done in America, for example, where advocates will tell the client, don't worry, I'll fund the litigation and I'll take a percentage or a contingency of what you get. And she's analyzed the law going back right to the Privy Council in Ram Kumar versus Chundar Mukherjee from 1876. Up to recent judgments of our Supreme Court in 2018. And I think that you all will find that this is an extremely well thought out, detailed, reasoned and analytical book. And it really gives us as the Bombay Bar Association immense pleasure in welcoming you all today to release this book. So with this short opening, could I request Dr. Kapadia to please present a small floral memento to Justice Srikrishna, who's taken time out from his still extremely busy schedule to come and preside over today's function. And could I call upon our member, Ms. Kaina Zirani, to present a small floral tribute to Dr. Kapadia.
No, that's for you, sir. So please from me. Thank
you. So, may I now request our President, Mr. Thakker, to say a few opening remarks.
Justice B.N. Srikrishna, former Judge, Supreme Court of India, my friend Naushad Engineer, Secretary, Bombay Bar Association, senior advocates present, all the friends, family members of Dr. Dhruti Kapadia, and of course, Dr. Dhruti Kapadia, the most important person. A very good evening. I am very happy that this is the fourth member of our bar who is publishing book, and Bombay Bar Association had the honor of hosting that event of publication of book. So Dhruti, well done, and we hope that more members will continue to write on some subject, and Bombay Bar Association will get opportunity to host such an event. Dhruti Kapadia's work on third-party funding in arbitration opens the door to discussions on these issues, including the question of whether India should accept and regularize third-party funding which is accepted globally. It remains an area where practitioners, tribunals and regulators are still seeking the right framework. The rules are fragmentary, the ethical questions are live, and the jurisprudence is still struggling to find its footing. It is into this gap that this book steps in with both rigor and ambition. The book also takes care to identify stakeholders, comparative study with regulatory landscape across jurisdictions with admirable thoroughness. She asks harder questions about the asymmetries of information that funding arrangements introduce into proceedings, about the tension between a claimant's access to justice and a funder's commercial imperative, about disclosure obligations and conflicts of interest that arbitral jurisdictions are only beginning to grapple with seriousness. These are not academic puzzles. They are questions that practitioners confront in real time, often without the benefit of settled authority and sometimes without even a coherent vocabulary to articulate the problem. In many cases, there are existing funders. They are neither legally recognized nor visible, as they remain undisclosed. The author argues that the third-party funding should not be treated as being against public policy today, but rather as a field that needs long overdue treatment, bridging the gap between the transactional world in which funding arrangements are negotiated and the procedural world in which their consequences unfold. She provides guidance and suggestions for the practitioner who needs to advise a client on whether to seek funding and what to disclose once they have it, as well as for the arbitrator who must rule on a disclosure application or assess whether a funding arrangement gives rise to a conflict. She writes that the regulator must decide whether to codify what has for too long been left to improvisation. Third-party funding raises at its deepest level questions about who gets to participate in the international arbitration system and on what terms. Access to arbitration has never been evenly distributed. Funding has the potential to rebalance that equation, to allow meritorious claims to be brought that would otherwise wither away for want of resources. But it also has the potential to introduce new imbalances, new dependencies, and new points of leverage that can distort the very proceedings they finance. This book holds both of those truths in view simultaneously, which is exactly the kind of intellectual honesty the subject demands. The book has contribution that is both timely and durable. Timely because the questions it addresses are unresolved, novel and durable because the analytical framework it offers will remain useful long after particular rules and decisions have been evolved. I am happy the topic has been introduced through the book and can be a matter of discussion for finding the road forward. Thank you very much, and I give my heartiest congratulations to Dr. Dhruti Kapadia for this book.
Could I now request Justice Srikrishna to please release the book? And if we could now have Justice Sri Krishna come and say a few words.
Nitin Bhai, Naushad, Dhruti, and all my friends gathered here. Third party funding is obviously a newfangled idea. But do we reject it because it is newfangled, or do we accept it and try to see if there are any shortcomings which can be crossed over, which can be taken care of, so that the larger benefit of a concept is available to the public at large. I remember having read long ago, when I used to be a good student, Kalidas said something very interesting. He said, Purana vidyeva nasadu sarvam nachadikavyam navamityavadyam santaha parikshya anyatarad bhajante murkhaha parapratyayene buddhi. He says, don't accept something because it is old, nor do we accept go around something because it is novel and came only yesterday. Santaha, this is the wise people, parikshya anyatarat, they examine it critically and accept that which is good for anybody. Murkhaha, stupid people, they go on for accepting everything on ears. So when Dhruti came to me and said she wanted to do a doctorate, God bless you for that, on this subject, I said, I don't know anything about the subject, but it's worthwhile examining the concept and see if what we say about it really is right or wrong. Now, I was born a British subject, so that British mentality was still persisting in me. I kept telling her that, hey, look, champerty, maintenance, all this, how can you have this kind of thing? And I also had in my own mind the contingency fees charged in America and what the accident tribunal lawyers do in India of taking away a chunk of the award. But I said, hey, this is my prejudice. In fact, I must confess at one time I was seriously opposed to this, saying that it is all nonsense, it should not be brought into India. But anyway, I was keeping an open mind and said, study the subject, research, look at all the literature, you might be able to get judged for yourself whether this is a concept that should be accepted, that should not be accepted. And then she gave her PhD thesis and obtained her doctorate on that. Now, I didn't realize at that time that I would be called upon to come and speak about the subject about which I really know nothing, and I must confess I have learned from Dhruti herself. Now, a few words on the subject itself, so that there is greater dissemination of concept. Imagine there is a legal claim. Perhaps a contract was breached, or one has suffered some serious wrong, and one simply cannot afford the cost of litigation. Now, I am going to address the subject generally about litigation as well as arbitration, although to some extent I think Dhruti favored talking about arbitration in her book. Third party funding refers to an arrangement where an external party, neither the claimant nor the respondent, finances the legal costs of a dispute in exchange for a share of the proceeds if the funded party wins. In essence, it is venue capital for litigation. At its core, I call it TPF, third party funded. TPF involves three parties: the claimant, the funded party's lawyer, the funder. Now, how was it looked at all over the world? I mean, we want to catch up with the world and we want to be the leaders of the world. We already claim that we are leaders of the world. Third party funding is well established in several jurisdictions. Australia was a pioneer in the matter, and they had a regulated market on the subject since the early 2000s. England and Wales also have a self-regulated market governed by the Association of Litigation Funders and a code of conduct formulated by them. Singapore and Hong Kong amended their laws in 2017 to permit TPF in international arbitration, recognize its importance to their status as a global arbitration hub. The United States has a thriving TPF market, and especially for class actions and commercial disputes. Now, what about third party funding, the concept and the law in India? India does not yet have a dedicated statutory financing framework for regulating TPF. However, that does not mean it is prohibited. The position is somewhat unsure. The common law doctrine of champerty and maintenance still holds sway in our country. Historically, English common law prohibited maintenance, that is supporting another litigation without lawful cause, and champerty, maintenance, where the supporter gets a share of the proceeding. India has inherited these doctrines from the Britishers thanks to the colonialism that they practiced. However, Section 23 of the Indian Contracts Act renders agreements void only if they are opposed to public policy. Indian courts would not have not applied champerty and maintenance as rigidly as older English courts did. In fact, the Privy Council's case, which Nitin referred to, in Ram Kumar Kundu versus Chandra, the Privy Council examined whether it is an agreement that is unconscionable or contrary to public policy, and on the facts they took a particular view. In Harilal Nathalal Talati versus Bhailal Pranlal Shah, the Bombay High Court invalidated a TPF as it was found to be extortionate. In Tomorrow Sales Agency Private Limited versus SPS Holdings, the Delhi High Court declined to impose security for costs against a third-party funder and distinguished the case from the well-known English decisions in Arkin versus Badshah Law Limited and Excalibur Venture LLC. Even the Civil Procedure Code, which is That's what is now, what is it called? It's not called anything now. It's the thank God for that now. Okay. Yeah, no new name. No, if it is a Sanskrit name, I have no problem, but I'm not sure what the Sanskrit name is. This Civil Procedure Code, Order 25, deals with security for cause and implicitly acknowledges that a third party may fund litigation. More significantly, Section 189 of the CPC permits certain classes of persons, such as tawais or agricultural financials, to fund litigation of others, suggesting that funding litigation is not inherently impermissible. Now, in arbitration, in the context of arbitration under the Arbitration and Conciliation Act 1996, there is no explicit provision that deals with TPF. However, there is equally no prohibition. Tribunals seated in India have generally not invalidated awards on the sole ground that the party was funded by a third party. Now, what are the key issues that arise in a situation like this? Do we accept it or do we reject it? The key issues and the concerns that arise, which has been very well discussed in the book of Dhruti, are first, conflict of interest and funder control. If a funder gains excessive influence over litigation strategy, it compromises the lawyer's independence and professional judgment. Bar council of rules in India require advocates to act in the client's best interest. A funder pushing for settlement or aggressive tactics may conflict with this duty. That is the first difficulty. There is no mandatory rule in India requiring disclosure of funding arrangement. This raises issues of transparency. Opposing parties and tribunals may be unaware that a powerful financial entity is driving the litigation. This is another difficulty. Then, in most litigation, a losing party is ordered to pay the winner's cost. In a funded claimant, if a funded claimant loses, can the funder be held liable for adverse costs? In India, this certainly is largely unsettled. Next, regulation of funders. Funders in India are not currently regulated as a class. They are not subject to SEBI, RBI, or Retd, or any other regulator having oversight in their capacity as litigation financiers. This creates a risk of undercapitalized or unscrupulous funders entering the market freely. Next, the ethical issue. On the other side, TPF has a genuinely democratizing potential. It allows individuals, MSMEs, and even states to pursue claims which could not have been otherwise afforded. Insolvency professionals and liquidators in India have shown great interest in TPF to fund recovery actions for the benefit of creditors. Now, the Insolvency Committee made a recommendation which is interesting, which shows the direction. A significant development came in 2018 when the Insolvency Law Committee report recommended that third-party funding be expressly permitted for insolvency resolution and liquidation proceeding under the Insolvency and Bankruptcy Code of 2016. The rationale was simple. Resolution professionals often lack funds to pursue fraudulent transfer claims or recovery actions, and TPF could fill the gap for the benefit of all the creditors. While this recommendation has not been acted upon and turned into a law, it signals that Indian policymakers are warming up to the concept. Now finally, international arbitration in India. India is increasingly positioning itself as an arbitration-friendly jurisdiction with amendments to the Arbitration Act in 2015, 2019, 2021 and many more to come. As India seeks to attract international arbitration, the absence of clear TPF rules is a competitive disadvantage compared to Singapore and Hong Kong, who are already 2 jumps ahead of us. The Mumbai Center for International Arbitration and the Delhi International Arbitration Center have both been discussing in their consultations on institutional rules, whether to agree to have TPF or not to have TPF, the debate is still on. There is a growing consensus among practitioners that disclosure of TPF to tribunals at the minimum should be mandated to allow the tribunal to screen for conflict of interest among the arbitrators. Finally, what is the way forward? Which is what the book is about. What does a sensible regulatory framework in India look like? Drawing from global best practices, it should include 1. Mandatory disclosure of the existence, though not necessarily the actual terms of a funding agreement to the tribunal or court. 2. Minimum capital requirements for funders to ensure that they can honor their commitments. Otherwise, what happens is that people make all kinds of claims and then they fizzle out. 3. A code of conduct for funders preventing undue interference in litigation strategy. 4. Clarity on adverse cost liability, whether funders can be joined as parties or made liable for costs. 5. Carve-outs for consumer and public interest litigation to prevent exploitation of vulnerable claimants. The Law Commission of India would be an ideal body to undertake a comprehensive review and recommend appropriate legislation on this subject. Finally, I would say third-party funding sits at the intersection of access to justice, legal ethics, and commercial innovation in India. It exists in a legal grey area, neither clearly permitted nor clearly prohibited. As India's arbitration ecosystem matures and cross-border disputes multiply, a clear, balanced, nuanced, and forward-looking regulatory framework with TPF is not just desirable, it is absolutely necessary. The question is no longer whether India will regulate TPF, but when and how they will. To sum up, I would say TPF is the idea which has come and it is time that we embrace it, but make sure, like all the medicine that you get there, make sure that the side effects are not going to be worse than the actual beneficial effect of the medicine itself. Thank you very much, and I am happy that I was in some way persuaded to change my thinking on the subject, and now I am also sitting on the fence and saying maybe it's a good idea, maybe it can be done. Thank you very much. Before I resume my seat, hearty congratulations to Dhruti and congratulations to her proud parents and family members who are all here. And like the others, I say, write more books and make us all educated. Thank you.
Thank you so much, Justice Srikrishna, for those insightful words and for that overview. And perhaps if Dhruti's book has made a change in your mind, it's something that maybe policymakers could even look at when actually framing a regulatory policy for third-party funding. So with this now, the woman of the hour, I'd like to call Dhruti to come and address the gathering.
Very good evening. Pranam, Namaste, Adab to everyone. And I feel really happy and elated to be amongst you all today. I really thank the Bombay Bar Association for supporting the little work that I have done by helping me organize this launch. A special thank you to Nitin Bhai Thakker sir, Honorable President Venkatesh Don sir, Vice President Naushad Engineer sir, and each and every member of the committee, including Kaina Sirani, Mehak Bukwala, who has also helped me promote this event here, and our staff supporting the event. Not that, I must say, the star publishers who are here, that is Mr. Nirav Bhatia, who made this book publish in a very short time. This was impossible otherwise, that I would have got the book today in a short notice. I can't stop thanking my mom, dad and sisters who have always encouraged me to achieve my goals in life, Not to forget my little nephew, Yuan and Hia, who played an important role by compromising the playtime with me while I invested my time writing this book. I must also thank my special dear colleague, my little sister at Bar, Ms. Kavita Dhanuka, for constantly helping me and supporting me in whatever I do. So this is very important. I must also thank Justice Srikrishna, who made this book happen. I would say, encouraging me with the subject I chose to write about. I must thank everybody here. I give a warm welcome to all my family, dear friends, senior members of the bar, my mentors who are all sitting here, and all my colleague friends and everyone who have come to support me in this event. And I'm truly fortunate that my book has been launched by two legends of our industry, that is Justice Srikrishna and Nitin Thakker, sir, in their presence and in everyone's presence here. Thank you so much. And Vimad Dalal sir, thank you to you also, because I remember discussing with you while I was doing my PhD. Listen sir, I am wanting you to say yes, that third party funding in India should be it. Even Yusuf Muchwala sir, Haresh Daktyani sir, Shailesh bhai sir, Nilesh bhai sir, everybody, Helekar sir, everybody like who has supported me. Because it just gives me encouragement when I debate, when I talk to my seniors. I have little thought which comes into a product only when I argue, discuss. I don't agree with all my thoughts always. I like to know where I'm wrong and what I can do better. So that's where I am with the book. Now the question is, why have I written this book? The answer to that is, as we know that every litigant can afford to pay litigation costs is not possible. So as a result, litigants needed to knock on the doors of the temple of justice and give up their rights due to lack of funds was always a problem which I saw. Therefore, the financial need arises. Legal aid cannot be a complete solution in all situations. Thus, funding from a third party would be necessary. So how? Many times people would come to me and say, we don't have the funds, should we not litigate? It's not only about arbitration per se, it is also about litigation that people would need funds. And I was like, this is the solution, I'm a legal aid panel counsel, please go there, they will give you a lawyer. Not everybody can afford that situation because that's not possible for all. So there's a way larger subject. Third party is not only for arbitration, I would say. It's not only for mediation process, not only for ADR, but also for litigations which are going on in court, which are high stakes in nature. So now further to move on and say, today third party funding is not accepted in our country for various reasons, which I think Justice Srikrishna has completely elaborated, and also Nitin Bhai Thakker has thrown light about it. So let's see how we can change it. So my strong recommendation would be drafting legislation to establish a mechanism that can incorporate all necessary safeguards while enabling third party in India as seen with various jurisdictions globally. So comparatively, when we study Singapore jurisdiction, we see USA, they have changed their mindsets and allowed third party funding to an extent. So why not our country? We are also in a commercial, competitive world, so why not put the foot and see if we can have some amendments being with safeguards and precautions. That's very necessary. So while writing the book, I also considered funders' role. That was very important for me to see. What will be the funders' role? Both from ethical and commercial perspectives, with few questions in my mind. Will there be heavy box of open door for litigations to enter in, which will allow this or not? I was so confused about all this. But then will it be against public policy was again a question while I was writing. How can we turn this process around while maintaining caution within the legal framework, so we can have some legal frameworks drawn up so that we can have this fit in our jurisdiction. I've also tried to answer and cover these aspects in my book. One way could be to include provisions for complete disclosures, that's very important, which could open access by justice by increasing transparency. There should be transparency. If the funder is there and he's there to say, look, I am funding so-and-so litigation, there should be disclosures made, even before the court, before tribunal, everywhere around, so people are aware about it. So I have split my book into short chapters and tried to answer few questions that have held us back from accepting third-party funding. My references along with the views in this book could be accepted by few or could not be. I leave the view to you all when you read the book. But this is something, a food for thought, which I thought that my PhD should not end here with just a thesis. It should be into a book which can be a cumulative thought process, or maybe acceptable notion of people now. I'm not too sure, but let's hope for it. So let us see if we can also help our country, India, implement third-party funding correctly, benefiting many litigants who cannot afford their own litigation costs while weighing the pros and cons after taking all precautionary measures. That could be ethics, that is very important. We must be very careful about it. So now about the book, just for 5 minutes, so I don't want to bore you all more. I have created 16 chapters in the book, each very brief enough, pretty brief enough. So there I have dealt with challenges, overcoming introductory of what our jurisdiction is, how we have done analysis with different various countries' jurisdiction, then what are the challenges, what is the way forward. So a small suggestion, the way forward, which I would just like to read for 2 minutes and not more. And that would just be a model outline which I have drawn out. That is, an ideal TPF model for India would aim to balance access to justice with safeguards to prevent abuse. This model would focus on what? So the answer here is access to justice, ensuring that marginalized groups and those with the limited financial resources can access legal representation and pursue meritorious cases. Also efficiency, that's very important. Streamlining disputes resolution, especially in high value and commercial cases, to reduce delays and ensure that cases with strong chances of success are prioritized. Then about fairness, funding agreements should be transparent with fair terms that do not exploit the litigant. A litigant should not be exploited. Then litigants should be fully informed about the terms of funding arrangements and their implications. The most important and very close to me is ethical standards. Legal professionals must maintain their independence with a clear separation between the roles of the funders and legal advisors. A regulatory body should ensure ethical standards are adhered to and funders do not exert undue influence over the cases. So you may read more if you like in the book, but this is some steps that I have put forward. If we target to draw a boundary line to it and incorporate some suggestions more than what I have in my book, maybe this can be a possibility of accepting today in India, because there's a need for an hour, I would say, in my view. This is just my view. Your views may be totally against what my view is, but this is what I have narrated in the book, and I'm very happy that everyone's come here, a food for thought. Maybe it could be, okay, not a topic to be discussed by few, but a topic to be discussed and taken forward by many, I would say. So thank you very much for hearing me out, and if any mistakes in the book, apologies, it's my first book, but I would love to hear from you if you read it around. Thank you so much. Thank you, sir. Thank you.
Thank you for making an implied promise to make another book. Huh?
Yes, I would try to. Always support. Thank you. Thank you.
Thank you, Dhruti. Are there any questions for the author?
Yeah. If anybody has, maybe. I think sir has answered all. They don't have any questions now.
But that still doesn't mean you don't buy the book, huh?
I would just request sir to read his forward. He has written a nice forward, if that's okay for 2 minutes, sir.
You can.
Yes.
All right, very well. This is the foreword written by Justice Srikrishna. There are books that describe a landscape, and there are books that arrive precisely when a landscape is being made. Dr. Dhruti Kapadia's work on third-party funding in arbitration belongs unmistakably to the second category. Third-party funding has, in a remarkably short time, moved from the wings of international dispute resolution to its center stage. What was once regarded with a mixture of suspicion and curiosity, a financing mechanism that seemed to sit uneasily with centuries-old doctrines of Champerty and maintenance, is today a sophisticated multi-billion-dollar industry that quietly shapes the strategy, economics, and even the outcomes of some of the world's most consequential arbitrations. And yet, for all its growing ubiquity, it remains an area where practitioners, tribunals, and regulators are still searching for the right framework. Rules are fragmentary, the ethical questions are live, and the jurisprudence is still struggling to find its feet. It is into this gap that this book steps with both rigor and ambition. What distinguishes Dr. Dhruti's treatment of the subject is her refusal to be satisfied with a surface-level description. After cataloguing the regulatory landscape across jurisdictions with admirable thoroughness, she asks harder questions about the asymmetries of information that funding arrangements introduce into proceedings, about the tension between a claimant's access to justice and the funder's commercial imperatives, about disclosure obligations and conflict of interest that arbitral institutions are only beginning to grapple with seriously. These are not academic puzzles. They are questions that practitioners confront in real time, often without the benefit of settled authority and sometimes without even a coherent vocabulary to articulate the problem. The field has long needed a treatment that bridges the gap between transactional world in which funding arrangements are negotiated and the procedural world in which their consequences unfold. Dr. Dhruti, drawing on her experience across both, provides exactly that bridge. She writes for the practitioner who needs to advise a client on whether to seek funding and what to disclose once they have it, but equally for the arbitrator who must rule on a disclosure application or assess whether a funding arrangement gives rise to a conflict. She writes too for the regulator and the institution that must decide whether to codify what has for too long been left to improvisation. TPF raises at its deepest level questions about who gets to participate in the international arbitral system and on what terms. Access to arbitration has never been evenly distributed. Funding has the potential to rebalance that equation, to allow meritorious claims to be brought that would otherwise wither for want of resources, but it also has the potential to introduce new imbalances, new dependencies, and new points of leverage that can distort the very proceedings they finance. This book keeps both of those truths in view simultaneously, which is exactly the kind of intellectual honesty the subject demands. Dhruti has produced a book that will be read with profit by anyone who encounters TPF in practice, and in the world of international arbitration today, that is increasingly everyone. It is a contribution that is both timely and durable, timely because the questions it addresses are unresolved, and durable because the analytical framework it offers will remain useful long after particular rules and decisions have evolved. I am extremely pleased to introduce it and hope that she will produce more such books to expand the horizons of knowledge of arbitrators, practitioners, and legal scholars. Thank you.
Just wanted to say the books I have been limited 5 of them today in a rush. I'll be having them soon after in a publication. The sort of line tomorrow, so I didn't want to miss the video. My apologies that the audience here I did not have the book quality. I'm really sorry about that.
So anyway, thank you everyone. That concludes our evening's function. Thank you to Justice Srikrishna for sparing his time, and it's absolutely correct. He in fact is flying out tomorrow. Despite being so busy, he has agreed to preside over today's function. Thanks to Nitin Bhai, the entire BBA committee, and all our staff for organizing this. And thank you all for being here, and thanks to Dhruti for educating all of us. So thank you, and congratulations to the proud family. Yeah, and there are some tea and there's snacks, so please do join us for the same.